Hello and welcome to BYJU'S IAS. In this video of Explained, let us discuss 10th schedule of the Constitution of India, anti-defection law. But why? Because of what happened in Karnataka last year, what happened in Madhya Pradesh this year, and what is happening in Manipur right now. Anti-defection law is in news. In this video, let us look at all that you need to know regarding anti-defection law. But how? First, we will understand the term defection. Then we will look at what was the need to bring in anti-defection law. What are the various provisions of anti-defection law? What are various exceptions to this law? Who gets to decide whether a legislator should be disqualified on the grounds of defection? We will look at various Supreme Court rulings on this matter. And then, what are these various loopholes in this law? And at the end, we will suggest a way forward, few solutions. So let's get started. But first up, what do we mean by defection? Let me give you an example. Let's say, for example, I was given a ticket by a party A and I won the election. But once the results were declared, party B emerged as the single largest party. That means in these elections, no political party was in a position to form the government on its own. Party B emerged as the single largest party, but it was still short of few MLAs. And what this party B is doing, it is bribing me. How? Maybe by offering money, maybe by offering a post of a minister. And what I do, I defect to party B, and now I am a part of party B, a minister in the government headed by party B. This is defection. It is also immoral. Why? Maybe the people of my constituency voted for me not because who I am, but maybe because of the ideology of my political party. And if I'm defecting from my party, I'm violating the trust of my voters. This is corruption. This is immoral. This had to be curbed. Let me give you another explanation. Let's say, for example, there is a state X and the strength of the Legislative Assembly is 100. The results were announced. Party A was in a position to form the government by bagging 55 seats. Party B is short and it has only 45 MLAs. But Party A, to which I belong, there are some individuals like me who are aspiring to become ministers. But we were not made ministers. So what we do, Party B has a lot of money. And Party B is now approaching us. Maybe with money, maybe with the lure of a post of a minister, maybe they are offering us that we will make you the head of a public sector undertaking. So ultimately what happens? Some of these MLAs, they jump the ship, they defect and move to Party B. Now Party B is in a position to form the government. This is defection, party hopping. But the curious case is of a Haryana politician, Gaya Lal. Elections were held in 1967 for the first time in Haryana because the state was carved out from Punjab. Gaya Lal won the election as an independent candidate. Within few hours, once the results were declared, Gaya Lal joined the Congress party. In the evening, Gaya Lal joined the United Front. And within 9 hours, Gaya Lal joined the Congress party again. That means Gaya Lal jumped the ship, changed his party 3 times within 9 hours. Rao Birendra Singh, he was the leader of the Congress party in Haryana, and he addressed a press conference in Chandigarh. Seated next to him was Gaya Lal. And what he said? He said, Gaya Ram, ab Aaya Ram hai. Gaya Ram is now Aaya Ram. So defection got a new term, Aaya Ram Gaya Ram. So Aaya Ram Gaya Ram is Haryana's gift to India's political system. But it didn't end here. Within a fortnight, within 15 days, Gaya Lal joined the United Front again. That means he changed his party many a times within a fortnight. But Haryana was back in news again. In 1979, Bhajan Lal, he toppled the state government headed by Devi Lal. And he was in a position to form the government. Bhajan Lal became the chief minister of Haryana. A year later, in 1980, Indira Gandhi stormed back to power at the center, and what Bhajan Lal did, along with 40 of his MLAs, he joined the Congress. This had to be curbed. these defections had to be curbed. It's because of this Aaya Ram Gaya Ram politics which led to the fall of more than 50 state governments since the enactment of the constitution in 1950. Then what happened? Rajiv Gandhi was the prime minister. The parliament enacted 52nd Constitutional Amendment Act. The year was 1985. 10th schedule was added to the constitution, and that is what we call anti-defection law. Now let's look at what are the various provisions of anti-defection law. Provision number 1. Let's say, for example, I am a member of a parliament, member of a house. This house can be either Lok Sabha or Rajya Sabha, Legislative Assembly or Legislative Council. If I am a member of a house and I belong to a political party, now if I voluntarily resign from my party, I will be disqualified under anti-defection law. That means voluntary resignation is something that will lead to disqualification under anti-defection law. That's provision number 1. Provision number 2, let's say for example, I belong to a political party A. I was given the ticket by party A, I won the election, and now I am a member of a house, whether Lok Sabha, Rajya Sabha, state legislature. And if a whip is issued by my political party, a directive is issued by my political party, and if I violate this whip, if I violate this directive, I will be disqualified under anti-defection law. But what is this whip? This whip is what we call a directive, but there are 3 types of whips. 1-line whip, 2-line whip, 3-line whip. It is this 3-line whip which is very dangerous. What is a whip? Let's say for example, I belong to BJP and I am a member of a house, of a parliament. Let's say I am a member of the Lok Sabha. And in Lok Sabha, a bill is to be discussed, and on this particular bill, voting has to take place. If my political party is asking me that you have to vote in favor of this bill, but I'm voting against this bill, that means I'm violating the whip issued by my political party. I will be disqualified from being the member of the House of the Parliament. But there is an exception. Let's say, for example, my political party asked me that you have to vote in favor of this bill, but I voted against. But my party has 15 days. Within 15 days, party may forgive me. Party may say that this is the last opportunity that we are giving you. Don't violate our whip again. Within 15 days, the party may condone my activity. The party may accept my action, and I won't be disqualified under anti-defection law. But within 15 days, if the party is not condoning my action and I have violated the whip of my political party, I will be disqualified under anti-defection law. But what are these 3 types of whips? Let's say, for example, 1-line whip. I am a whip of a political party. That means I am in charge of managing the members of my political party who are the members of a house, who are the MPs or MLAs or MLCs. I inform them that tomorrow there is going to be a vote in the parliament. That's it. It's just an information. 1-line whip informing the members of my political party who are members of the House of a Parliament that tomorrow there is going to be a vote on one particular issue. That's it. The members of my political party, they can violate this 1-line whip. But then there is a 2-line whip. I am informing the party members who are part of a house that tomorrow there is going to be a vote on a particular matter, on a particular bill. Please be present. That's it. The members of my political party, who are the members of the house, they may violate this whip. They may not be present in the house. No action can be taken against them. But then there is a 3-line whip. Informing the members of my party that tomorrow there is going to be a vote on a particular bill. Please be present and please vote in favor of this bill. And if you vote against this bill, you are liable to be disqualified under anti-defection law. But even then, the political party has 15 days to forgive this member who has violated their whip. But at the end of this 15-day period, if the party has not condoned the action of this member, ultimately he or she shall be disqualified under anti-defection law. So what was the need to bring in anti-defection law? We discussed that. What are the provisions of this law? Number 1, a member of a house belonging to a political party, if he voluntarily resigns from this party, disqualified under anti-defection law. Provision number 2, if the whip is issued by a political party, a 3-line whip, and the member of the parliament belonging to your political party, if he or she is violating this 3-line whip, disqualified under anti-defection law. Provision number 3, I am an independent member of the parliament. I do not belong to any political party, which means I am the independent member of a house. Whether the house is Lok Sabha, Rajya Sabha, Legislative Assembly, Legislative Council, after my election, if I join any political party, I will be disqualified. That means an independent member of a house, after his election, if he joins another political party, disqualified under anti-defection law. But you might ask that there are number of independent members who are also ministers. It is possible because they don't join a political party. They support this political party or they support this government as an independent entity. So they are not joining a political party, but they are supporting the government. It is as if this individual member, this independent member of the house is like an individual political party. And since in a government, there can be many political parties coming together to form a coalition government, that does not lead to disqualification. But if an independent member of a house joins a political party after the election, disqualified under anti-defection law, he can still be a minister without joining a political party because you are supporting the government. And this government is making you a minister, but you will not be disqualified because you are not joining this political party. Then we have another provision. We have a concept called nominated members. For example, in Rajya Sabha, there are 12 nominated members nominated by the President of India from the fields of art, literature, science, social service. All these nominated members, they are given an option. Within 6 months of your nomination, you can join a political party. That means if I am nominated today to Rajya Sabha by the President of India, for example, I am Justice Ranjan Gogoi, who was nominated to Rajya Sabha by the President of India. Within 6 months of my nomination, I can join a political party. But if I am joining a political party 6 months after my nomination, I will be disqualified under anti-defection law. These are the various provisions under 10th schedule of the Constitution of India. But there is also an exception. What is the exception? Let's say, for example, there is a political party A. This political party has 30 members in a house. If, for example, 2/3 of these 30 members, they decide to join another political party X, they will not be disqualified. But what will happen to the remaining 1/3? They may continue to be the members of the political party A, or they may also decide that we will continue as a separate political group, as a separate political entity, neither part of A nor part of X. That means anti-defection law will not apply in case there is a merger. In case there is 2/3 merger of a political party merging with another political party. There is another exception. Let's say, for example, I am the Speaker of Lok Sabha, or Speaker of Legislative Assembly, or Deputy Speaker of Lok Sabha, or Deputy Speaker of a Legislative Assembly, or Chairperson of Legislative Council, Deputy Chairperson of Legislative Council, Deputy Chairperson of Rajya Sabha, which basically means you are a member of a political party, you are a member of a house belonging to a political party, but because you are elected to these important constitutional offices, what you can do, you can voluntarily resign from your party. Because you have been elected as the Speaker of Lok Sabha, you want to appear impartial. That is why after my election as the Speaker of the Lok Sabha, I decide to voluntarily resign from my party. I will not be disqualified under anti-defection law, because otherwise a member of a house belonging to a political party, if he voluntarily gives up the membership of his political party, he will be disqualified under anti-defection law. But there is an exception. If you are elected, for example, the Speaker of Lok Sabha, I am elected as the Speaker of the Lok Sabha, I belong to a political party A, I can voluntarily resign from this party A after my election as the speaker. And while I am continuing as the speaker of the Lok Sabha, I should not join the party A again. I should not join any other political party. And if I join, while I'm still the speaker of the house, if I join party A again or any other political party, I will be disqualified under anti-defection law. Another case. I am elected as the speaker of the Lok Sabha. I belong to a political party A. Now my term is over. Maybe, for example, I am removed as the speaker of the Lok Sabha. What will happen to my membership? I cannot stay as an independent member of the Lok Sabha. I will have to join this party again, the party which gave me ticket to contest the election. And if I am joining any other political party except A, I will be disqualified under anti-defection law. But who gets to decide whether a legislator should be disqualified on the grounds of defection or not? Anti-defection law states that this decision shall be taken by the Speaker or the Chairman. Speaker of Lok Sabha, Speaker of Legislative Assembly, Chairperson of Rajya Sabha, Chairperson of Legislative Council. An anti-defection law states that the decision of the Speaker or the Chairman shall be final and binding. But then the matter went to the court. The year was 1992 in a landmark case, Kehota Holahan versus Zachilhu. The question before the court was, when Speaker gets to decide whether a legislator should be disqualified or not on the grounds of defection, is the power of the Speaker final? Is the decision of the Speaker final and binding? Supreme Court said no. Why? Because judicial review is part of the basic structure of Indian Constitution. That means even after the Speaker or the Chairperson has taken a decision, the Supreme Court will have the power to review the decision taken by the Speaker or the Chairperson, because judicial review is part of the basic structure of the Indian Constitution. Now, even after 1985, there was a loophole. Let's say, for example, I am a member of Lok Sabha, I belong to political party A. But now political party B needs my support in forming the government. But if I decide to join this political party B, I will be disqualified under anti-defection law. So why would I resign and join this party B? But this time, what party B is doing? Party B is offering me a minister post. Party B is saying, even if you are disqualified, we will make you a minister. Within 6 months, you will be re-elected on my party ticket to the Lok Sabha. That means don't worry. If you are resigning from your political party, which means you are disqualified, even if you are disqualified, we will make you a minister. If not minister, we will make you head of a public sector undertaking. We will make you head of a statutory organization. And Atal Bihari Vajpayee was the Prime Minister. Constitution was amended again. Parliament enacted 91st Constitutional Amendment Act. The year was 2003. And what this amendment did, it barred a defector from holding any remunerative political post. That means if I am a member of this political party A, and if I am defecting to party B, I am disqualified under anti-defection law. Till the time I am re-elected to the House, till the time I am re-elected to the legislature, I cannot hold any remunerative political post. And what is the meaning of this remunerative political post? Any post for which the salary, for which the allowances is paid out of public revenue. That means you can't be made a minister, you can't be made the head of a statutory organization, you can't be made head of a public sector undertaking, because this amendment has made it clear a defector is barred from holding any remunerative political post till the time you are re-elected. Which means after you have been disqualified, if you contest the election again, you win the election again, then you can be made a minister, you can be made head of a public sector undertaking. We don't have a problem with that. But you have to gain the trust of the people of your constituency again. But there was another issue. Who can complain? Because the rules made under anti-defection law said that if a legislator, whether he or she should be disqualified or not, because the speaker has to take the decision, who can complain to the speaker? Only a legislator. That means if you think that an MP or an MLA or an MLC should be disqualified under anti-defection law, this decision has to be taken by the speaker or the chairperson of a house. Who can complain to the speaker? Who can complain to the chairperson? Only a legislator. Then came a curious case. The case was in Odisha. What happened? Four members of Nationalist Congress Party, NCP, they decided to jump the ship and they joined BJD of Naveen Patnaik. The president of the state NCP is complaining to the speaker that these four MLAs who belong to the NCP, now they have voluntarily resigned, they have joined the BJD, please disqualify them under anti-defection law. But the speaker says, I can't entertain your complaint. Why? Although you are a president of the NCP, but you are not a legislator. You are not an MLA of Odisha Legislative Assembly. So I cannot accept your complaint. Matter went to the court. Speaker, Odisha Legislative Assembly versus Utkal Keshari Parida. The year was 2013. Supreme Court said, legislator alone, no. Any voter can complain to the speaker. Any voter can complain to the chairperson that these legislators should be disqualified under anti-defection law. That means the rules under anti-defection law, which stated that who can complain to a speaker, who can complain to a chairperson, that person has to be a legislator. Supreme Court struck it down. Supreme Court said any voter has the locus standi to file a complaint before the office of the speaker or the chairperson under anti-defection law. That means today if you think that a legislator should be disqualified on the grounds of defection, even you can file a complaint before the speaker or the chairperson. Then there was another interesting case. The first provision under anti-defection law states that a member of a house belonging to a political party, if he or she voluntarily gives up the membership of his party, which means if he or she voluntarily resigns from his party, this person shall be disqualified under anti-defection law. But here the interesting point is voluntary resignation. What do we mean by voluntary resignation? Supreme Court said in Shri Rajendra Singh Rana and others versus Swami Prasad Maurya and others. In this case, Supreme Court said voluntary resignation does not mean that this legislator should submit his written resignation, should submit his formal resignation, and only then this legislator should be disqualified under anti-defection law. No. If we look at a legislator, but his conduct outside the house is such that it can be safely assumed that he has voluntarily resigned from his party, which means there is a political party A, I am the member of this political party A, I am the member of the parliament belonging to this political party A, but I'm not attending the meetings of this political party. I am openly criticizing the political party. I am openly attending the meetings of the opposition political party. I am supporting the candidates of the opposition political party. Even then, I have not submitted my formal resignation. Even then, I have not submitted my written resignation. Does that mean I should also be disqualified under anti-defection law? In this case, Supreme Court said, it does not mean that this individual should submit his formal written resignation and only then he can be disqualified under anti-defection law. No, because this phrase voluntary resignation would mean that my conduct outside the house, if it is such that it can be assumed that I have resigned from my political party, I have voluntarily given up the membership of my political party, even without submitting formal resignation, even without submitting written resignation, I shall be disqualified under anti-defection law. Curious case again, Sharad Yadav and Anwar Ali, members of the JDU, headed by the Bihar Chief Minister Nitish Kumar. Sharad Yadav openly criticized the party for aligning with the BJP. Sharad Yadav was attending the rallies of the opposition political parties, despite the fact that JDU had asked Sharad Yadav not to do that, not to violate the directives of the political party. Ultimately, matter went to the chairperson of Rajya Sabha. Who is the chairperson of Rajya Sabha? M. Venkaiah Naidu, the Vice President of India. and JDU filed a petition before the Vice President of India that Sharad Yadav and Ali Anwar should be disqualified under anti-defection law because their conduct outside the parliament is such that we can safely assume that they have voluntarily given up the membership of the JDU. Vice President accepted this. Sharad Yadav and Ali Anwar were disqualified under anti-defection law. That means this phrase, voluntary resignation, does not mean you have to submit a formal resignation or a written resignation. If your conduct outside the house is such that it can be assumed that you have voluntarily given up the membership of your political party, you will be disqualified under anti-defection law. But now there are some issues. What are these issues? Issues are primarily because of the fact that the speaker or the chairperson, they belong to the ruling political party. And if they belong to the ruling political party, obviously they will be biased in favor of the ruling political party. They will be biased against the opposition political party. So whether A should be disqualified or not, if A is aligning with the ruling political party, speaker is not acting at all. If A is aligning with the opposition political party, immediately the speaker issues an order. Under anti-defection law, A is disqualified. But the real problem is also because of the fact that there is no time limit. There is no time limit within which the speaker has to take his decision. That means if a legislator, he clearly has defected, he clearly has resigned, but if this legislator is supporting the ruling political party, the speaker does not act at all. And why the speaker does not act at all? Because the law does not define any time limit. And to understand this, I will give you a very interesting example of what happened in Telangana. There was one member of the Legislative Assembly of Telangana, T. Srinivas Yadav. T. Srinivas Yadav was a member of TDP, Telugu Desam Party. And ultimately, he won the election and was a member of the Legislative Assembly. After the election, he joined TRS of KCR. And KCR is the Chief Minister of Telangana. Various petitions were filed before the Speaker that T. Srinivas Yadav should be disqualified under anti-defection law. The Speaker is not acting at all. Why? Because T. Srinivas Yadav is supporting the ruling party. In fact, T. Srinivas Yadav was also made Minister for Commercial Taxes and Cinematography, despite the fact that law clearly says that a defector should not be holding any remunerative political post. Matter went to the court. Telangana High Court said we are helpless. Why? We have the power of judicial review. That means once the speaker takes a decision, then we can review whether the decision is correct or incorrect. But first, let speaker take a call. Let speaker make up his mind. The speaker is not acting at all. Why speaker is not acting at all? Because the legislator is supporting the ruling political party and the speaker belongs to that ruling political party and the speaker is biased in favor of the ruling political party. Because the loophole is there is no time limit prescribed under the law within which the speaker has to take a decision on the matters of defection. So what is the solution to this? The solution is prescribe a time limit, a reasonable time limit. Time limit can be 1 month, 2 months, 3 months, 6 months. So if there is a complaint against a legislator that this legislator has defected and should be disqualified under anti-defection law, the speaker should take a decision within 6 months at least. Because why would it take such a long time for a speaker to answer a simple question whether he should be disqualified or not? So there has to be a time limit prescribed under the law within which the speaker has to take a decision. Or if you can't prescribe a time limit, don't give this power to the speaker. Give this power to the president or the governor who will act on the report of the Election Commission of India. How? Let's say, for example, there are various other grounds under which a legislator can be disqualified. One such ground is if a legislator is holding office of profit, disqualified. If there is a change in the nature of citizenship of a legislator, I was an Indian when I contested the election. Now when I am a legislator, I have acquired the citizenship of Germany. Shouldn't I be disqualified? Yes. That means if there is a change in the nature of citizenship, disqualify this legislator. But who takes this decision? This decision of disqualification is taken by president if it is parliament, governor if it is the state legislature, but president and the governor does not act on its own. The president and the governor acts on the report of the Election Commission of India, and the report of Election Commission of India is binding on the governor or the president. That means whenever it is to be found whether a legislator should be disqualified on the grounds of office of profit, on the grounds of mental unsoundness, on the grounds of change in the nature of citizenship, a report is prepared by Election Commission of India, and whatever Election Commission of India says in its report, that is binding on the president or the governor. So even under anti-defection law, don't give this power to the speaker, because speaker is biased in favor of the ruling political party. Give this power to the Election Commission of India, and the report of the Election Commission of India should be binding, final on the president or the governor. But now let's come to the curious case. What happened in Karnataka? What happened in Madhya Pradesh? What is happening in Manipur right now? And we will ask a very important question: is democracy at stake? What happened in Karnataka? Elections were held. No political party was in a position to form the government on its own because the elections through a hung assembly. BJP emerged as the single largest party, but two political parties, Congress and the JDS, they decided to come together and form the government. But what the governor of Karnataka did, invited BJP to form the government because BJP emerged as the single largest party in the elections. But very soon, BJP was not in a position to prove majority on the floor of the Legislative Assembly. Mr. Yediyurappa had to resign as the Chief Minister of Karnataka, and Kumaraswamy of JDS became the Chief Minister of Karnataka. But it was not long lasting. Why? Some MLAs of Congress, some MLAs of JDS, they decided to voluntarily resign from their political parties, joined BJP, and ultimately the government of Congress and JDS fell. When the government fell, BJP was in a position to form the government. And what happened to these MLAs who voluntarily resigned from their political parties? The Speaker of Karnataka Legislative Assembly, who was then the member of the Congress, what the Speaker did, he disqualified all these defectors and disqualified them for the remaining term of the House. That means there are still 3.5 years left for the election. These 17 MLAs who have voluntarily resigned from their political parties, I'm going to disqualify them, but I'm going to disqualify them for the remaining term of the House. That means for 3.5 years, they cannot enter the Legislative Assembly. Matter went to the Supreme Court. Supreme Court said, yes, the Speaker may be right in disqualifying them under anti-defection law because they have voluntarily resigned from their political parties. But don't disqualify them for the remaining term of the House. They should be allowed to contest the elections as well. And once the elections were announced, for those seats which fell vacant, majority of them, they won the trust of the people again, they won the election again, and some of them were also made ministers under the BJP government in Karnataka. So the problem here is now, resignation is another loophole in anti-defection law. Why resignation is a loophole? Let's say, for example, 100 is the strength of the Legislative Assembly. Political party A has 60 MLAs. Political party B has 40 MLAs. Can political party B form the government? No. The only way political party B can form the government is if 25 of these MLAs, they voluntarily resign. Now, if these 25 MLAs, they voluntarily resign, which basically means that the strength of the Legislative Assembly right now is only 75, which means 40 is more than half of 75. Party B is in a position to form the government. That means resignation is now another loophole under anti-defection law. You can still resign, you can still be disqualified, you can contest the election again, win the election again, join the political party again. You are making mockery of democracy. And that is why the real reform suggested by many is that even resignation should not be allowed. Even if there are MLAs who are resigning, even if there are MPs who are resigning, yes, you have the right to resign, but you can't join the House again for the remainder of the term. That means you should be disqualified under anti-defection law for the remaining term of the House. That can be the biggest reform in anti-defection law, and that will preserve the democracy for a long time in India. This is exactly what happened in Madhya Pradesh as well. Resignation is being viewed as a tool, as a loophole under anti-defection law. There was a Kamal Nath government, a Congress government in Madhya Pradesh, but Jyotiraditya Scindia, along with 20 odd of his followers, 20 odd MLAs, they decided to resign from the Congress. And ultimately, what happened? The strength of the Legislative Assembly reduced. When the strength reduced, ultimately BJP was in a position to form the government. So the reform could be, even if MLAs or MPs can resign, but they should not be in a position to contest the election again for the remainder of the term. That is going to make resignation a tough choice for these defectors, and that is how we can preserve democracy. But not just in Madhya Pradesh. What happened in Goa? In Goa, Indian National Congress emerged as the single largest party. Next in line was the BJP. The governor of Goa invited BJP to form the government. BJP was supported by 3 MLAs of MGP, and 1 MLA of MGP was a deputy chief minister as well. And ultimately what happened? These 2 MLAs, they decided to merge with BJP and became the members of the BJP, because the law allows two-third merger. Two-third MLAs can merge with another political party. Some people say even this should not be allowed. Why? Because it may be difficult to break a political party which has 50 MLAs or 100 MLAs, but it is very easy to break a political party which has 3, 5, 10 MLAs. And if there is a political party A which has a lot of money in its bank account, it has the potential to bribe any number of legislators, and thereby you are again making a mockery of democracy in India. So 2 things here: resignation, even if allowed, but if you resign, you should be disqualified for the remainder of the term. That will strengthen anti-defection law. 2, this two-third merger should also be disqualified. Because to break a political party which has more than 20, 30 MLAs is difficult, may be difficult. But to break these smaller parties is very easy, and this should not be allowed because you're making a mockery of democracy in India. But you might ask, what is the judiciary doing? Is Supreme Court sleeping? But finally, the Supreme Court may have woken up. Why? 2017, elections were held to Manipur Legislative Assembly. 60 is the strength of Manipur Legislative Assembly. Congress emerged as the single largest party with 28 MLAs. BJP was next in line with close to 21 or 22 MLAs. But what happened? The governor of Manipur invited BJP to form the government, and BJP was in a position to form the government. 8 MLAs of Congress, they resigned and they joined the BJP. They should have been disqualified under anti-defection law, but the speaker is not acting at all. Because these defectors, they are favoring the ruling political party. The speaker is a member of the ruling political party. The speaker is not acting at all. In fact, one Congress defector, T.H. Shamkumar, he was made a forest minister as well. Matter went to the court. A 2-judge bench of the Supreme Court headed by Rohinton Fali Nariman. What the Supreme Court did? Supreme Court, in a rare move, invoked the powers under Article 142. Under Article 142, Supreme Court can issue any order, Supreme Court can issue any directive so as to give complete justice. And what Supreme Court said? Supreme Court said this cabinet minister should not be allowed to enter the Legislative Assembly of Manipur. Why? Because there is a case pending against him. Whether he should be disqualified or not, let Speaker take a call whether this cabinet minister should be disqualified or not. Till the time Speaker takes a decision, he cannot enter the Legislative Assembly, and he is also removed as a cabinet minister. So in a rare move, Supreme Court woke up. 2-judge bench of the Supreme Court, use the plenary power under Article 142 to give complete justice, removed a cabinet minister and prohibited this cabinet minister from entering the legislative assembly. And ultimately what happened? The Speaker of Manipur Legislative Assembly disqualified this cabinet minister, disqualified from the House of Manipur Legislative Assembly. But it did not end here. What about the remaining MLAs against whom the petition was pending that they should also be disqualified under anti-defection law? Rajya Sabha elections were to be held. What the Speaker of Manipur Legislative Assembly did, those MLAs who could have voted for the Congress, they were not allowed to vote. Those MLAs who could have voted for the BJP, they were allowed to vote. If we look at Rajya Sabha, we call Rajya Sabha Council of States. We call Rajya Sabha a federal chamber of Indian Constitution because it represents the interests of the states. There was election to one Rajya Sabha seat in Manipur. These MLAs against whom proceedings under anti-defection law were pending, if these MLAs Speaker thought they will vote for the Congress candidate, they were not allowed to vote. If the Speaker thought that these 4 MLAs who may vote for the BJP, these 4 MLAs were allowed to vote, and 3 out of these 4 MLAs voted for the BJP. So basically, Rajya Sabha, which is supposed to protect the interests of the states, which is supposed to represent the interest of the states, in Rajya Sabha, the MP of Rajya Sabha from Manipur is not representing the will of the state of Manipur, is representing the will of the Speaker of the Legislative Assembly of Manipur. And again, violating the trust of the people, making the mockery of democracy. So these are the loopholes in anti-defection law. But let's conclude this lecture with the observation of the Supreme Court and the Manipur case. Supreme Court said a time has come that Parliament should rethink whether we should entrust Speaker with the power under anti-defection law, because the Speaker is the member of the ruling political party. He may not be unbiased. And that is why we have to rethink about the role of the Speaker in anti-defection law, and we need serious reforms in anti-defection law. Reform number 1, prescribe a time limit within which the Speaker should take a decision under anti-defection law. If not the Speaker, give this power to the Election Commission of India. Also, resignations, even if allowed, but if you are resigning from the House, you should be disqualified for the remainder of the term of that House. And also, 2/3 merger should not be allowed because you are making a mockery of electoral system. Thank you for being with us. Have a great day.